वो किसी और केस के बारे में बात करें। for Judgement 1501.
It was a great pleasure to hear submissions on behalf of all the learned counsel. We have had a tough time, but there are 4 judgments to be delivered in this matter. I'll first invite my learned brother, Justice Dinesh Maheshwari, to declare his view.
With reference to the questions which we had formulated, and thereafter with reference to the submissions made by all the learned counsel, these are the 3 major issues, or rather 3 major points for determination formulation as to whether reservation is an instrument for inclusion of socially and educationally backward classes to the mainstream of society, and therefore reservation structured singularly on economic criteria violates the basic structure of the Constitution. B, as to whether the exclusion of classes covered under Articles 15.4, 15.5 and 16.4 from getting benefit of reservation as economically weaker sections violates the Equality Code and thereby the basic structure doctrine. C, as to whether reservation for economically weaker sections of citizens up to 10% in addition to the existing reservations results in violation of basic structure on account of reaching the ceiling limit of 50%. These points for determination have been dealt with reference to the relevant constitutional provisions, doctrine of basic structure and constitutional amendments. Thereafter, the segments of the judgments are expanding doctrine of equality, affirmative action by reservation, exception to the general rule of equality, economic disabilities and affirmative action, whether economic criteria as sole basis for affirmative action violates basic structure, EWS reservation not availing to certain classes, whether violates basic structure, breach of 50% ceiling of reservations and basic structure, and then there are other factors and summations. After having dealt with these aspects, the conclusions are as follows. For what has been discussed and held herein above, the points formulated in paragraph 31, I just read there, are answered as follows. Reservation is an instrument of affirmative action by the state so as to ensure all-inclusive march towards the goals of an egalitarian society while counteracting inequalities. It is an instrument not only for inclusion of socially and educationally backward classes to the mainstream of society, but also for inclusion of any class or section so disadvantaged as to be answering the description of a weaker section. In this background, reservation structured singularly on economic criteria does not violate any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India. B, exclusion of the classes covered by Articles 15.4, 15.5 and 16.4 from getting the benefit of reservation as economically weaker sections, being in the nature of balancing the requirements of non-discrimination and compensatory discrimination, does not violate Equality Code and does not in any manner cause damage to the basic structure of the Constitution of India. C, reservation for economically weaker sections of citizens up to 10% in addition to the existing reservations does not result in violation of any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India on account of breach of the ceiling limit of 50% because that ceiling limit itself is not inflexible and in any case applies only to the reservations envisaged by Articles 15.4, 15.5 and 16.4 of the Constitution of India. Not much of the contentions have been urged in relation to the impact of the amendment in question on admissions to private unaided institutions. However, it could at once be clarified that what has been observed here and above in relation to the principal part of challenge to the amendment in question, read with the decision of this court in Pramati Trust, the answer to the issue framed in that regard would also be against the challenge. Accordingly, and in view of the above, the answers to the issues formulated in these matters are as follows. One, the 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions, including reservation, based on economic criteria. Two, the 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions in relation to the admission to private unaided institutions. Three, the 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution in excluding the SEBCs, OBCs, SCs, STs from the scope of EWS reservation. Consequently, the transferred cases, transfer petitions, read petitions, and the petition for special leave to appeal forming the part of this batch of matters are dismissed. Our acknowledgements while closing on this reference, sincere thanks and compliments deserve to be placed on record for the learned counsel for the respective parties, their associates and their researchers, and also all the constructive contributors whose erudite and scholarly presentation of respective viewpoints has rendered invaluable assistance to this court in shaping the formulations herein. Thank you.
I'll now invite Honorable Justice Bela Trivedi to place her view.
I have concurred with the opinion of Brother Justice Maheshwari. However, have penned down certain my views also. I'll just read them out. As well settled, it must be presumed that the legislature understands and appreciates the needs of its own people. Its laws are directed to the problems made manifest by experience, and its discriminations are based on adequate norms. Therefore, the constitutional amendment could not be struck down as discriminatory if the state of facts are reasonably conceived to justify it. In the instant case, the legislature, being aware of the exclusion of economically weaker section of the citizens from having the benefit of reservations provided to the SCs, STs, and SCBCs citizens in clause 4 and 5 of Article 15 and clause 4 of Article 16, has come out with the impugned amendment empowering the state to make special provisions for the advancement of EWS other than the classes mentioned in clause 4 and 5 of 15 and clause 4 of Article 16. The impugned amendment enabling the state to make special provisions for EWS of citizens other than SCs, STs, and SCBCs is required to be treated as an affirmative action on the part of the Parliament for the benefit of and for the advancement of the EWS of the citizens. Treating EWS of citizens as a separate class would be a reasonable classification and could not be termed as unreasonable or unjustifiable classification, much less a betrayal of basic feature or violative of Article 14. As laid down by this court, just as equals cannot be treated as unequals, unequals also cannot be treated as treated equally. Treating unequals as equals would be as well offend the doctrine of equality enshrined in Article 14 and 16 of the Constitution. The SCs, STs, and backward class for whom the special provisions have already been provided in Article 14, 15.4, 15.5, and 16.4 form a separate category as distinguished from the general or unreserved category. They cannot be treated at par with the citizens belonging to the general or unreserved category. The impugned amendment creates a separate class of EWS from the general or unreserved class without affecting the special rights of reservations provided to the SCs, STs, and SCBCs. Therefore, their exclusion from the newly created class for the benefit of EWS in the impugned amendment cannot be said to be discriminatory or violative of Equality Code. Such amendment could certainly not be termed as shocking, unconcernable, or unscrupulous travesty of quintessence of equal justice as sought to be submitted by learned counsels for the petitioners. The sum and substance is that the limitations that is substantive or procedural imposed on the exercise of constituent power of the state under Article 368 could not be said by any stretch of imagination to have been disregarded by the Parliament. Neither the procedural limitation, that is the mode of exercise of amending power, has been disregarded, nor substantive limitation, that is the restricted field, has been disregarded, which otherwise would invalidate the impugned amendment. What is visualized in the preamble and what is permissible, both in Part 3 and Part 4 of the Constitution, could not be said to be violative of the basic structure or basic feature of the Constitution. In absence of any obliteration of any of the constitutional provisions and in absence of any alteration or destruction in the existing structure of equality code or the basic structure of the Constitution, neither the width test nor the identity test as propounded in Keshwanan could be said to have been violated in the amendment. Accordingly, the challenge to the constitutional validity of 103rd Amendment fails and the validity thereof is upheld. And before parting, I have expressed my views on the time span to be prescribed for the reservation policy. I have quoted the observations made by the Constitution Bench in K.C. Vasant Kumar, observations of Justice D.A. Desai, Justice Venkatramaiah, Justice Chandrachud as he then was, and also in case of Ashok Kumar. And at the end, I said, what was envisioned by the framers of the Constitution, what was proposed by the Constitution Bench in 1985, and what was sought to be achieved on the completion of 50 years of the advent of the Constitution, that is, the policy of reservation must have a time span, has still not been achieved even till this day, that is, till the completion of 75 years of our independence. It cannot be gainsaid that the age-old caste system in India was responsible for the origination of this reservation system in the country. It was introduced to correct the historical injustice faced by the persons belonging to the SCs, STs, and other backward classes, and to provide them a level playing field to compete with the persons belonging to the forward classes. However, at the end of 75 years of our independence, we need to revisit the system of reservation in the larger interest of the society as a whole, as a step forward towards the transformative constitutionalism. Be it noted that as per Article 334 of the Constitution, the provisions of Constitution relating to the reservation of seats for SCs and STs in the House of People and in the legislative assemblies of the states would cease to have effect on the expiration of the period of 80 years from the commencement of the Constitution. The representation of Anglo-Indian community in the House of Parliament and in the legislative assemblies of the state by nomination has already ceased by virtue of 104th Amendment, that is with effect from 25th January 2020. Therefore, similar timeline, if prescribed, for the special provisions in respect of the reservations and representations provided in Article 15 and 16 of the Constitution, it would be a way forward leading to an egalitarian, casteless, and classless society. Thank you so much.
May I now invite Justice Paradiwala to place his view?
While concurring with my esteemed brother, Justice Maheshwari, and my esteemed sister, Justice Bila Trivedi, and while upholding the validity of the impugned amendment, I have thought fit to observe, I quote, thus, reservation is not an end, but a means to secure social and economic justice. Reservation should not be allowed to become a vested interest. Real solution, however, lies in eliminating the causes that have led to the social, educational, and economic backwardness of the weaker sections of the community. This exercise of eliminating the causes started immediately after the independence, that is almost 7 decades back, and it still continues. The long-standing development and the spread of education have resulted in tapering the gap between the classes to a considerable extent. As larger percentages of backward class members attain acceptable standards of education and employment, they should be removed from the backward categories so that the attention can be paid towards those classes which genuinely need help. In such circumstances, it is very much necessary to take into review the method of identification and the ways of determination of backward classes, and also ascertain whether the criteria adopted or applied for the classification of backward is relevant for today's conditions. The idea of Baba Sahib Ambedkar was to bring social harmony by introducing reservation for only 10 years. However, it has continued past 7 decades. Reservation should not continue for an indefinite period of time so as to become a vested interest. In the result, I hold that the impugned amendment is valid and in no manner alters the basic structure of the Constitution. Thank you.
Finally, I invite Justice Ravindra Bhatt to place it.
I regret my inability to concur with the views expressed by the majority opinion on the validity of the 103rd Amendment on question number 3, since I feel, for reasons set out elaborately in the following opinion, that this court has for the first time in the seven decades of the Republic sanctioned an avowedly exclusionary and discriminatory principle. Our Constitution does not speak the language of exclusion. In my considered opinion, the amendment, by the language of exclusion, undermines the fabric of social justice and thereby the basic structure. I am of the opinion that the application of the doctrine of classification, differentiating the poorest segments of societies as one segment, that is the poor beneficiaries of reservation, and the other, the poorest who are subjected to additional disabilities due to caste stigmatization or social barrier-based discrimination, the latter being justifiably kept out of the new reservation benefit, is an exercise in deluding ourselves that those getting social and educational backwardness-based reservations are somehow more fortunate. This classification is plainly contrary to the essence of equal opportunity. If this constitution means anything, it is that the code of articles 15.1, 15.2, 15.4, 16.1, 16.2, and 16.4 are one indivisible whole. This court has reiterated time and again that Article 16.1 and 16.4 are facets of the same equality principle. That we need Articles 15.4 and 16.4 to achieve equality opportunity guaranteed to all in Articles 15.1 and 16.1 cannot now be undermined through this reasoning to hold that the theory of classification permits exclusion on this very basis. The characterization of including the poor, that is, those who qualify for economic eligibility, among those covered under Articles 15.4 and 16.4 in the new reservations under 15.6 and 16.6 as bestowing double benefit is incorrect. What is described as benefits for those covered under Articles 15.4 and 16.4 by the Union cannot be understood to be a free pass, but as a reparative and compensatory mechanism meant to level the field, where they are unequal due to their social stigmatization. This exclusion violates the non-discrimination and the non-exclusionary facet of the Equality Code, which thereby violates the basic structure of the Constitution. The impugned amendment creates pathways, gateways, and opportunities to the poorest segments of our society, enabling them multiple access points to spaces they were unable to go places and positions they were unable to fill, and opportunities they could not hope ever to ordinarily lose due to their destitution, economic deprivation, and penury. These destitution, economic deprivation, poverty are markers or intelligible differentia, forming the basis of the classification on which the impugned amendment is entirely premised. To that extent, the amendment is constitutionally indefeasible. However, by excluding a large section of the equally poor and destitute individuals based on their social backwardness and legally acknowledged caste stigmatization from the benefit of the new opportunities created for the poor, the amendment practices constitutionally prohibited forms of discrimination. The overarching principles under Articles 15.1, 15.2, 16.1, and 16.2 is that caste-based or community-based exclusion, that is the practice of discrimination, is impermissible. Whichever way one would look at it, the Constitution is intolerant towards discrimination and untouchability in all forms and manifestations which are articulated in Articles 15.1, 15.2, 16, 17, 23, and 24. It is equally prohibits exclusion based on past discriminatory practices. The exclusion made through the other than exclusionary clause negates these principles and strikes at the heart of the Equality Code, specifically the non-discriminatory principle, which is a part of the core of the Constitution. The Sinnoh Commission was set up. The Sinnoh Commission was set up to examine the condition of economically backward and suggested measures, including the feasibility of reservations to improve their law. The report published in July 2010 is based upon the census of 2001 and later surveys. The statistics NSSO 2004-2005, which the report is based on, disclosed that in all 31.7 crore people were below the poverty line, BPL, of which the scheduled caste population was 7.74 crores. That is 38% of the total of the scheduled caste population in the country. Scheduled tribe population was 4.25 crores, that is 48.4% of the total scheduled tribes of the country. 13.86 crores of OBC population, which was 33.1% of the total OBCs, and 5.85 crores of the general category, which is 18.2 the total general category. These facts established that the bulk of the economically weaker sections of the society belong to the classes described in Articles 15.4 and 16.4. I pass on to question number 2, which is that unaided private institutions, including those imparting professional education, cannot be seen as standing out of the national mainstream. As held in Pramati and Society for Unaided Private Schools, reservations in private institutions is not per se violative of the basic structure. Thus, reservations as a concept cannot be ruled out in private institutions where education is imparted. They may not be the state or state instrumentalities, yet the value that they add is part of the national effort to develop skill and disseminate knowledge. These institutions, therefore, also constitute material resources of the community, in which the state has a vital interest and are not merely bodies set up to further private objective of their founders, unlike in the case of shareholders of the company. Therefore, I hold that on question number 2, the amendment is valid, but for reasons of answering question number 3, the amendment has to go. Before I sum up, I wish to address one point which the majority has dealt with, but more as a note of caution, because it is not necessary for me to deal with that aspect, which is the 50% cap. It is pertinent to note that the breach of the 50% limit is the principal ground of attack of the 76th Constitutional Amendment, 1994, which is inserted as entry 257A. The Tamil Nadu backward classes, scheduled caste and scheduled tribe reservation of seats in educational institutions under the State Act 1993. The validity of that enactment and whether the inclusion by the Constitution Amendment violates the basic structure is directly in issue in a batch of cases pending before this court. The view of the members of this bench constituting a majority that the creation of another class which can be a recipient of up to 10% of reservation over and above 50% permitted under 15.4 or 16.4 in my considered opinion therefore has a direct bearing on the likely outcome in the challenge in that proceeding. I would therefore sound this cautionary note, since this judgment may well seal the fate of the pending litigations without the benefit of hearing in those proceedings. The last reason why I find myself unpersuaded to agree with the opinion that the amendments, by creating a different kind of criteria, have to be viewed separately, and that Indira Sani was confined to reservations under 15.4 and 16.4, is because permitting the breach of the 50% rule, as it were, through this reasoning becomes a gateway for further infractions, whereby, which in fact would result in compartmentalization. The rule of reservation could well then become the rule of equality or the right to equality, could then be easily reduced to the right to reservation, leading us back to the days of Champakam Durai Raja. In this regard, the observations of Ambedkar have to be kept in mind that reservations are to be seen as temporary and exceptional, or else they could eat up the rule of equality. The fraternal principle, I'm now summing up. The fraternal principle is deeply embedded to this nation's ethos and culture. The specific provisions which form part of the Equality Code are inextricably intertwined with fraternity as well. It is fraternity and no other idea which acknowledges that ultimately all individuals are human beings born through the same natural process, subject to the same physical limitations, and finally leave this world at an unknown time but are sure to live. Fraternity is as a concept, awakens humans to the reality that despite our apparent or superficial differences, ethnic, religious, caste, gender, origin, or economic status, the institutions we create need our collective cooperation and individual commitment. Every social order invariably contains individuals with differences, be grounded on ethnicity, wealth, talent, or realization of one's abilities. The diversities abound. The idea of fraternity is to awaken to the consciousness of each member of society that our institutions which are created, the ideas that we develop, and the progress that we wish to achieve cannot be in isolation, by separation, but with cooperation and harmony. On this, I want to highlight the words of two social reformers, which demonstrate that the principle of fraternity and the ideas and values connected to it are not new, but in fact transcend time. Swami Vivekananda's message in his address to the World Parliament of Religions in Chicago on 11 September 1893 has the theme of universal brotherhood of all, that differences in religion, the exclusion of one of other would fade. He evocatively said, if anybody dreams of the exclusive survival of his own religion and destruction of others, I pity him from the bottom of my heart and point out to him the banner of every religion will soon be written, in spite of resistance, help and not fight, assimilation and not destruction, harmony and peace and not dissension. Aurobindo too was conscious of the need for fraternity. In a speech delivered in Howrah in 1909, he presciently said, again, there is fraternity. It is the last term of the gospel. It is the most difficult to achieve, still it is a thing towards which all religions call and human aspirations rise. There is discord in life, but mankind yearns for peace and love. This is the reason why the Gospels will preach brotherhood, which preach brotherhood, spread quickly, and excite passionate attachment. This was the reason for the rapid spread of Christianity. This was the reason of Buddha's spread in the country and throughout Asia. This is the essence of humanitarianism, the modern gospel of love for mankind. None of us have achieved our ideals, but human society has always attempted an imperfect and limited fulfillment of them. It is the nature, the dharma of humanity, that it should be unwilling to stand alone. Every man seeks the brotherhood of his fellow, and we can only live by fraternity with others. Through all its differences and discords, humanity is striving to become one. Summary of findings in questions 1 and 3. On question 1, it is held that the state's compelling interest to fulfill the objectives set out in the directive principles through special provisions on the basis of economic criteria is legitimate. That reservation or special provisions have so far been provided in favor of historically disadvantaged communities cannot be the basis for contending that other disadvantaged groups who have not been able to progress due to the ill effects of poverty should remain so, and the special provision should not be made by way of affirmative action. Therefore, the special provisions based on objective economic criteria is per se not violated. However, in answer to question 3, I have highlighted the framework within which it has been introduced by the impugned amendment, excluding backward classes. According to me, this is violative of the basic structure. A universally acknowledged truth is that reservations have been conceived and quotas created through provisions in the Constitution only to offset fundamental, deep-rooted generations of wrongs perpetrated on entire communities and castes. Reservation is designed as a powerful tool to enable equal access and equal opportunity. Introducing the economic basis for reservation as a new criterion is permissible. Yet, the othering of socially and educationally disadvantaged classes, including SCs, SCs, and OBCs, by excluding them from this new reservation on the ground that they enjoy pre-existing benefits, is to heap fresh injustice based on past disability. The exclusionary clause operates in an utterly arbitrary manner. First, it others those subjected to socially questionable and outlawed practices, though they are amongst the poorest sections of the society. Secondly, for the purpose of new reservation, the exclusion operates against socially disadvantaged classes and castes absolutely by confining them within their allotted reservation quotas. Thirdly, it denies the chance of mobility from reserve quota based upon past discrimination to a reservation benefit based only on economic deprivation. The net result of the entire exclusionary principle is Orwellian, so to say, which is that all the poorest are entitled to be considered regardless of their caste or class, yet only those who belong to other classes or caste would be considered, and those from socially disadvantaged classes would be ineligible. Within the narrative of the classification jurisprudence, the differentia or marker distinguishing one person from the other is deprivation alone. The exclusion, however, is not based on deprivation but social origin or identity. This strikes at the essence of the non-discriminatory rule. Therefore, the total and absolute exclusion of constitutionally recognized backward class of citizens is nothing but discrimination, which reaches to the level of undermining and destroying the equality code, and particularly the principle of non-discrimination. Therefore, on question 3, it is clear that the impugned amendment and the classification it creates is arbitrary, results in hostile discrimination of the poorest segments of society that are socially and educationally backward and are subjected to caste discrimination. For these reasons, Articles 15.6 and 16.6 are struck down and held to be violative of the Equality Code, particularly the principles of non-discrimination and non-exclusion, which form an inextricable part of the basic structure of the Constitution. While this reasoning is sufficient to conclude that Article 16.6 is liable to be struck down, there are additional reasons elaborated in Part 5, due to which this court is compelled to clarify that while the economic criteria per se is permissible in relation to access to public goods under Article 15, the same is not true of Article 16, the goal of which is empowerment through representation of the community. For the above reasons, it is hereby declared that Sections 2 and 3 of the Constitution 103rd Amendment Act 2019, which inserted Clause 6 in Article 15 and Clause 6 in Article 16 respectively, are unconstitutional and void on the ground that they are violative of the basic structure of the Constitution. The writ petitions are consequently disposed of. It would be in order to place my gratitude and appreciation for the valuable assistance rendered by all counsel and all the counsel assisting them.
I have concurred with the view taken by Honorable Justice Ravindra Bhatt in its entirety. So effectively, the decision is 3-2.
Oh.
So immensely grateful to your lordship.
We are expressing a deep gratitude for the assistance rendered by every one of you in whatever capacity as the lead counsel, as even as nodal counsel. These two counsel did excellent job. So it was a great learning experience for all of us. And this, I express gratitude on behalf of all the members who are part of this bench. My colleagues also join me in expressing that. Thank you so much.
Immensely grateful.
Pleasant bench, not a pleasure to argue before your lordship. Greatly obliged.
We are grateful for your lordship's to accommodate and hear everyone. We are very grateful for that, your lordships.
The operative portion will be like this. In view of the decision rendered by the majority consisting of Honorable Justice Dinesh Maheshwari, Honorable Justice Bela M. Trivedi, and Honorable Mr. Justice J.B. Pardiwala, the challenge raised to the 103rd Amendment to the Constitution fails. The writ petitions and other proceedings filed in that behalf stand disposed of accordingly. Thank you.
Grateful to you.
Grateful to your lordship.
Sir, may I also thank the bench for a very patient and
Thank you.
very.
It was a great learning experience, Dr. Mohan Gopal.
Grateful. Grateful.
Please, your lordship. But my first respectful submission, and that if accepted, my lord, you may save your lordship's time, that the reference itself was not required. And I'll make that good, my lord, without wasting much of the time. My lord, kindly have a look at the reference order, my lord. Your lordships would find in my volume 1.
Let's keep the original volumes because
Hmm?
Just see, it will be convenient for us to look at there because we marked that volume.
I'm sorry.
Now, volume,
I'll
two volumes will create its own
Malad,
extra effort for us.
yes. And Malad, some of the judgment which my learned friend did not cite, which I'll show from my volume, because there your lordships have not seen. Yes.
Honestly, I think the arguments have gone beyond what is the reference, what is the issue before us.
No, that's what I want to
No,
show.
but we are confining to the issue only. As you said, so we did not let any argument take place beyond that. We also did not let the other points. We were apprehensive about some of the other points evolving, and because of one more council appearing, we did not permit all those.
No, certainly, Malad. I'll not.
Let me rephrase what I have in mind and
My
discuss it. I would say on behalf of the bench. There is a protection provided to the officers. That protection in one form or the other continued for a long period of time. Ultimately, the statutory provision was struck down on the short ground that it was discriminatory, not that it was bad in law.
My lords.
Grant of protection per se was not held to be bad in law. What was held was you cannot give protection to one group and not give protection to the other. This is the limited issue on this. Some hiatus period occurred, ordinance was issued, and then you brought in a legislation to cure the defect which the court pointed out by giving limited protection to certain categories. Chapter is over. Now, to some extent, it's theoretical in nature, because what would happen for the interim period, how many cases they pointed out last time in some affidavit, it was stated that the number of cases were 100 odd or something, out of them some may be also over. But let's look at the facts of the petitioner. He was protected. No difficult. Because of his judgment, he became unprotected. Now, because of the other judgment, does he become protected again? So he says, as far as I am concerned, I am still protected merely because the protection was lifted for some period of time. It should not damage. And to our mind, one of the most crucial aspects is it was not merely a reenacting of legislation which took place, where it was held that this legislation was bad in law, but on the ground of a particular defect. Which defect stands cured? Would you agree that this is the position? It's the only issue before us.
Look, may I say, Malad, without touching the.
Except one aspect which Mr. Datar said, which I find some force, which is a larger issue, he says, for us to say, not in specifically this case, that when such provisions struck down, he says, look, the court must give some guidance how it will operate. So, if it is prospective, the court specifically says it is prospective. If it is to apply retrospectively, it is not said. So, some scenarios maybe, it's a general observation, may be taken into account